My name is Don Linky. It is April 23, 2008. We're here on the campus of Rutgers University at the Eagleton Institute of Politics. This is another in the series of video interviews for the Brendan T. Byrne archive of the Rutgers program on the governor. We'll be talking to Sandy Jaffe, continuing an earlier interview with him about his relationship with Governor Brendan Byrne. Let's talk a little bit more about the Boiardo case and also generally about the influence of organized crime and the Mafia in New Jersey. The Boiardos, and both Anthony and his father, Rosario Richie Boy Boiardo, were fairly prominent figures, allegedly, as Mafia leaders in those days. Growing up in Newark, what do you recall about the Mafia, if anything?
Well, my recollections growing up in Newark are really more limited to the operations of the numbers business, which basically is a lottery that a lot of people, but many poor people play, where they will go to a particular store or some kind of a facility, and they will put money down on three numbers and hope that those three numbers will be the winning number, and they'll get a return. If you put a nickel on, you probably could win $120 or $130, which in those days was fairly significant money. And the way in which the winner was determined was by looking in the New York Daily News, and there was a cartoon in the New York Daily News. I forget the name of the cartoon, but in the cartoon was a character, and in one of the comments that the character would have would always include three numbers. And the three numbers were the last three numbers of the pari-mutuel handle at one of the racetracks in New York. And that's how you would find out the winning number. Well, when I was growing up, my dad had as I mentioned before, my dad had a candy store in Newark on Hawthorne Avenue, which he acquired in 1932 and kept until 1939, which, as you know, was the height of the Depression. And like many store owners at that time, he tried to earn a few extra dollars by taking numbers. And so every morning, customers would come in and buy a newspaper or a cup of coffee or something like that, and give my dad a nickel or a dime, and they would he'd write down the three numbers on a slip of paper. They'd keep that, and another slip of paper with the money would go into a paper bag. And at the end of the day, it was my job, even though I was kind of small in those days, 6 or 7, it was my job to take that paper bag with nickels and dimes and the numbers and bring it up to a store which was 3 or 4 blocks away, run by, it was a tobacco store, and that was called the Drop. And people in that area where we lived, all the various store owners would come there and bring the paper bag with the money and the numbers. And then at the end of the day, in the evening, somebody would come from one of the organized crime organizations who basically ran the numbers, and then pick up from each one of these drops, et cetera, and et cetera, that was my job. Suffice to say, I escaped detection and avoided all kinds of contact with law enforcement at that time. Even though I told Brendan that story when we talked about hiring me, he was willing to look it over. I had no formal record and felt that was a youthful folly and necessary at that point. The only other interesting thing is that at one point, the police did come to our store and raided our store. And I remember my mom being very upset about that. They searched our store, but it was one of those days I had already gone and made the drop, so nobody ever found anything. So my parents were fine. But to answer, Don, I think that my recollection of those days was that organized crime was a fairly tight enterprise. As you said, I think the Biardos were were allegedly one of the major figures in the organization. Therefore, the Biardo case became a very, very important case, and a case that got a lot of attention in the press. And it was interesting that the only charge against Biardo was the contempt of court charge that I talked about that because of the failure to answer questions and whether it was appropriate to take the Fifth Amendment. But I don't think law enforcement, from my recollection at that point, both from the federal side and the state side, was really focused as much on organized crime as subsequently happened. As you know, when Kennedy became president and a little bit before, and Bobby became Attorney General, that focus began because the Kefauver Committee in, I guess, the late 50s began to bring attention to the role of organized crime in American life, and that began a whole different approach. And but I think in the early days, I was in a prosecutor's office. I think if we arrested someone or somebody was involved in organized crime, it was prosecuted. But I don't recall at that point any specific squad or emphasis on it. Although we did have, a lot of cases involving numbers, runners, or banks, but rarely able to actually move against the higher ups.
Taking you back a little bit, in your youth, as you're making the drop, did you understand the system, or did you ask your dad, what am I doing here?
I sort of understood it a little bit. I understood what I was doing, and I understood that, my dad was doing this, and, I saw it more as an accommodation to customers, and I saw it more as an opportunity for us. In the height of Depression, running a small candy store was not the easiest way to make a living. My parents started at 6 o'clock in the morning and closed up at 9 or 10 o'clock at night. We lived in the back of the candy store in 2.5 rooms. So it was difficult to make a living, not only for my dad or for many people in the Depression. And so I think he got a small percentage of what they took in, and on occasion, if one of your customers was a winner of the lottery, the tradition was that they would then give you $5 or $10, that as a good faith little bonus of the thing. But the implications, which I later found out in a prosecutor's office, those of your 6 or 7 were really not major issues for me at that point.
Did your dad caution you about talking to your friends about the system?
No, not really. I don't recall. I think I just did it, and this is my dad asked me to do it, and I just did it. I don't think there was any that I can recall. I mean, it was obviously a long time ago, but I don't recall any conversations. And I remember even when the police came, and I must have been 6 or so. I remember my parents being upset about it, but I think that quickly passed after that. We went back to trying to make a living in the store.
Mm-hmm. Any other memories of the prosecutor days that you wanted to talk about?
Well, I always liked I think that it was an extraordinary experience, working in a prosecutor's office. I think Brendan was a very, very good prosecutor. And I think Brendan had a really good sense of fairness and a really good sense of justice. And I think he handled things in a very professional way. And I learned an awful lot. I came out of law school, and as you know, I clerked for the Chief Justice. But the reality of what was happening in both law enforcement and the role of law and all that were something that you really don't pick up in those two places. And one of the things Brendan insisted that I do, even though, as I said, I was in charge of the appellate section, and I think last time I told you when Brendan was out of the office, I'd asked one of the guys if I could try a case, which gave me a great deal of experience, was that he also insisted that I spend some time in the Newark Magistrates Court. And I did that for a couple of weeks. And he thought that this would be a good learning experience for me, and it was. Understand what was happening in the Magistrates Court, understand what kind of cases never came to the prosecutor's office, so I'd get a full sense of it, and see what kind of justice was being handed out at that level. So that was a very good experience. And then later on, I also got the opportunity to run a couple of grand juries, which were in itself an excellent experience. One of the things I think I mentioned before, I don't know if I mentioned before about my role in pornography. Did I? Oh, well. Brendan, at that point in the prosecutor's office, there was a sheriff. I can't recall his name. But the sheriff thought that pornography, nudist magazines, etc., were really the scourge of society. So he went on what I thought was somewhat of a rampage, and would go and try to arrest store owners who were selling what at that time were considered salacious, but today would not be in any way considered salacious material. And he would arrest these people with big fanfare. We ended up with a whole bunch of free speech and Fourth Amendment cases. And he would come into the prosecutor's office and he would dump huge, what do you call those, like big baskets of material with magazines and books, and prosecute these guys. And Brendan, I thought, he really tried to deal with that in a very, very sensible way. He was not out to rid the county of every magazine in the world that somebody did not like. He really knew the importance of the First Amendment to the Constitution. On the other hand, he did feel that where there was a violation of the statutes on pornography, that was something we had to prosecute. So what Brendan decided one day is he called me in the office and he said, since I was the only unmarried person in the prosecutor's office, that ought to be my responsibility. And so I said, okay.
Was that considered a benefit?
I think it was just Brendan's perverse sense of humor. And as you know, Brendan sometimes has that. And so I got that responsibility. And so I used to present these cases to the grand jury. And one funny incident, so I would work with one of the detectives, and I would tend to take these trash bins and break the magazines. These were nudist magazines, these were girly magazines, that's what they called them in those days, or this were books, and I put them in various, and so I bring this up to the grand jury, and since I believed that I tried my best when I went up to the grand jury, you can use hearsay, but my theory was that try to bring in the direct witnesses, because if you can't make the case in a grand jury, you're clearly not going to make it, a trial. So I would bring all these magazines into the grand jury, and when they arrested and they had films, I had actually show the films to the grand jury. So one day I'm getting ready to do all this, and Brendan approved of this. He said, okay, you want to do it, you do it your way. That sounds fine. And I figured that would be helpful we get also a sense of community standards. See which was the test at that time, whether or not it violated community standards. So I tell the grand juries, the grand jury is composed of 23 people. And you needed 12 to actually get a bill. You only need a majority. So one day I told all the grand jurors, the grand juries were usually equal men, women, all different ages. And I said, look, we're going to bring in cases that allegedly are pornography. We're going to show some films, and we're going to spend a whole session on this, a 3-hour session on this. And if any of you have feelings that you might not want to watch this, you may not want to read about this, you may feel that this is inappropriate for you, don't come. As long as we have 12 here, at least we can vote an indictment, and we'll be concerned about that. So I give this long speech and all that. And I also tell this to all the clerks of the grand jury. And so next week, I bring all my things up and ready to make the presentations. And I look and I see 23 members of the grand jury are there. And all the clerks are there.
Full house.
Full house. I always thought that was kind of interesting thing. But to me, it was a good example of Brendan's sense of looking at the Constitution, looking at fairness, looking at what were the competing interests here, and trying to really balance them, in a very, very fair way. And one time, I remember Brendan, myself, and Judge Masucci, we got a complaint that the Little Theater in Newark were showing pornographic movies. So that I don't remember how it worked out, but the three of us went to the movies that time. It was really one of the funniest scenes. I don't think nothing happened as a result of it, but I always remember it as a cute story.
I think we have a photograph in the archives of Prosecutor Byrne presiding over the burning of pornography. Do you recall that?
That I do not.
Outside in the
I know that the sheriff did that on occasions. I don't recall Byrne ever being there. You have a photograph, that's true. I can tell you I was never there. Book burning of any kind had never been my suit. But I did know it. I didn't know that.
Mm-hmm. Any other prosecutor office memories?
Well, I think it was an efficient office. One of the things I also liked that Brendan did is every Friday morning we had a staff meeting. And Friday morning was motion day in court. And I think they didn't start until 11 or something. And so we had a staff meeting. And Julie Feinberg, who was one of the assistant prosecutors, had been there for many years. Julie would stop and buy cakes and bagels and all that. I remember the food was good. And we'd all sit in Brendan's office, which in those days, 11 prosecutors you could do. But the thing I remember most was I think it was the first session I went to after I went to the prosecutor's office. And a fellow a defense lawyer by the name of Sam Baza, Brendan had invited to speak to the prosecutors. And he was going to talk about jury picking. And what I'll never forget, what really struck me is now I've come out of law school and I've clerked for the Chief Justice, and I'm listening to this very serious defense lawyer telling me that how he picks jurors is he looks at their physical makeup of their face and where the forehead is and how large the nose is and all of this theory. There's a name for it.
Ology, something.
Yeah, something like that. I'm saying to myself, I never learned this in law school. The contrast was that I remember afterwards I said to Brendan, "It's really serious." He said, "Well, it's good for you to learn this stuff." And then they were usually very good sessions. Generally, Brendan would always try to bring somebody in who could talk about a particular issue or a particular viewpoint on law or a trial technique or tactic of that sort. So the learning experience, from my standpoint, continued. I will say, though, that after a year of writing briefs, I did get bored. I found writing briefs in criminal cases not to be the most interesting, creative things to do, particularly since, as you know, Don, a practicing lawyer, 3/4 of the brief was the basic restatement of what the law is on all these things. And I had a system where I had didn't have computers in those days. I had a system where I had the books all piled up with the pages, and I'd have the secretary just type in the first 3/4 of the brief, and then I'd work on the last quarter, which was trying to analyze the case.
Now, you had mentioned that while Prosecutor Byrne was on vacation, you tried the manslaughter case.
Yes.
And actually got a conviction despite your
My
ineptness.
Absolutely. And my lack of, it taught me to prepare, if nothing else.
Did you discuss the case with Brendan Byrne after he returned, or weren't you proud of your performance?
I never, I think Brendan knew what was going on, but I tried to keep that part of my life secret from Brendan so that he wouldn't tell anybody in the office not to give me cases to try. Not that I thought Brendan would do it, but I figured, well, he was gone. He's gone for the day or for 2 days, and I'd ask one of the other assistant prosecutors, let me try that and that kind of thing. And so I figured, well, I'll keep that secret from him.
Now, you said you're getting somewhat bored writing appellate briefs.
Right.
And I assume that means you're starting to think about your next career move.
Well, I tried to, I talked to Brendan about it. And I said to Brendan, you think it's time for me to become one of the trial attorneys? And, Brendan kind of hemmed and hawed and said, look, you write briefs well. You know Joe Weintraub. You know the court. The court respects you. They look at your briefs and they know they're going to respect it. He said, I don't have anybody else, really. And until I can get somebody, I'd really like you to continue doing that. And that's when he said, look, you can do the grand jury. And then he did say, well, and occasionally if you can, try a case. So he was not ready to move me into the trial section. I tried to do other things, really.
Going back to the Boyardo case for just one last time.
Sure.
Do you think that the fact of your clerkship with the Chief Justice and your relationship with the court might have led Brendan Byrne to suggest that you argue the rehearing?
Yeah, I think, Brendan never really articulated that. Of course, Brendan knew I was familiar with all the justices. I honestly think that what motivated Brendan were really two things. One is that I think he knew this was a very important case. Not only was going to important from a legal standpoint, the law involved was important, but I think he realized this was a case that was being followed very closely in the press and followed a lot in law enforcement. And so he knew this was a case that wanted to make sure was presented as best we could. And I think when the court came down and asked these subsequent questions, I think Brendan is a good lawyer and a sensitive guy. And I think Brendan honestly believed probably that since I had worked so closely with him, that somebody with a different perspective and a different way of presenting it might be more appropriate at this point. I think the fact that the court knew me and the fact that I had clerked for the Chief Justice, I'm sure that went into his calculations. I would guess it did, thinking that, well, if nothing else, they'll be respectful to me, maybe, which was not necessarily the case. But I think that it was primarily that he really did think, we ought to look at this from another perspective. That's very much like Brendan. I remember once, many years later, you remember Brendan was on the New Jersey Bell Board, I think, at one point. And just about the time that, I forget the name of the judge in District of Columbia, ordered the breakup of AT&T, which was a major case. I guess that was, in the 70s or 80s, I think, or early 90s. Anyway, I ran into Brendan at some point, and we were talking, and Brendan said, he said, a little late now, but I wish I had thought about you. And I said, why? He said, I would have loved, I was on a board, he said, of New Jersey Bell, I would have wanted to try to see if we could hire you with a group of people to take a look at the AT&T issue and the breakup issue and give us a different perspective. And I don't telecommunications was not my field, but I tell the story mostly because I think that's very much like Brendan from my experiences with him. That and many times in the governor's office when I would talk with him on occasions, I think that when he saw an issue and he thought it was explored and it was a contentious issue, he thinks that maybe by other people taking a look at that issue, you'd get a different view and a different perspective, which I think is an extraordinarily good trait and an important trait. So, well, at that point, the breakup had already been ordered by the court. It would have been not a serious issue. And whether it would ever have come to pass, that wasn't the issue. The point is that it's somewhat analogous to the Biardo case because it shows his frame of mind and how he wanted to look at things. I mean, I think I've always found that in trying to understand people that I've gotten to know well, is I try very hard to understand how they think about things and what they do. And I used to try that with Weintraub. Obviously, Weintraub, I was a clerk, I wasn't too successful. But occasionally I would ask him questions that would give me a great insight also into how he would think about it. And I think last time I did tell a story about how that one case we handled now, Weintraub, told me how he would look at it, and he would look at it in a broader framework and understand the economic and social conditions.
Going back to the old common law.
Common law. I mean, it reminds me one day Weintraub, to digress for a moment, we were working on a criminal case, and brief, and I was looking at the brief, and as I said, the clerks would write short memos. So this person must have had 18, 19, 20 points for reversal. And finally, the last point was, and I'm sure you may have seen these kind of last point in the brief was, if none of those points on their own are sufficient for the court to order a reversal, the totality of all those 19 points should be sufficient for a reversal. So I walked into the chief and I said, I'm trying to figure out how do I deal with this argument in my memo. He looked at it and he said, you throw away the brief. And it was a tremendous insight into the way he thought, which was analyze the case, analyze the fact situation, try to think of the 3 or 4 things that are going to be operative in making a decision, balance those, and that if you've got to throw the, quote, the proverbial kitchen sink at something, you really haven't thought through. You don't have a very good argument. And when I tried cases, when I got to the U.S. Attorney's Office and I did get to try cases, that lesson always stood with me. And no matter which case I tried, I would try to sit down and say to myself, what are the 2 or 3 facts here that will make a difference to a jury or a judge? No matter how complicated the case was, if I could find those 2 or 3 facts, then I would constantly, with all my witnesses and all my oral arguments, summation or opening arguments or even in motions, I would always not always slant it, always talk about that. And it was really, that came from my insight that Weintraub had given me. I'm going to tell you one more. Go ahead, I'm sorry.
Well, Chief Justice Weintraub was also known for writing opinions that, in contrast with most opinions from appellate courts, cited very few precedents in terms of case law. Was that frustrating for you as a clerk after doing all this research and looking up the cases and giving him all these precedents, that he would ignore them when he came down to write the opinion?
Not really, because in law school I developed an anathema to all these precedents, and frankly, although I understood it, I never did understand the value of a CF site, that's analogous, or but CF, and each. You remember all that stuff that was in the law review blue book on how to cite cases, and I always thought that was just a filler. I really did. And while I think precedent obviously has an important role in the law, in the common law, but I think this half a page of citations, and particularly footnotes, used to bother me no end. I thought they were mostly an irrelevant way of writing. And if something was important, you discussed in the text, and the footnotes ought to be used very sparingly, which was really contrary to a lot of legal scholarship. If you, as you know, you pick up a law review article, and the text is 2 lines, and the footnote goes on for 20 pages. So I thought Weintraub was very good in doing that, and I think that his sentences were always very short. They were generally declarative sentences and extraordinarily logical, because that's the way he approached it, and very clear. And which reminds me, when you talk about footnotes, I don't know if I told this story, but it's one of my favorite Weintraub stories. There was a very, can I talk this? There was a very important case before the New Jersey Supreme Court, and the issue was the extent of the Privileges and Immunities Clause in the Constitution as applicable to a senator. And what the case was, it's McCarthy.
I think you did discuss.
Oh, I did? Oh, okay, then I don't have to repeat the McCarthy case. But that was also an interesting way in which Weintraub would operate.
Okay.
I'm repetitive enough, Don. I don't have to be more.
And I know we're flipping around a little bit, but on the Boiardo argument, given that your family had some knowledge of the Mafia in Newark, and I assume
At a very low level.
at a very low level,
I don't want a grandiose connection.
but I assume they knew the sort of pervasive influence at that time
Right.
of the Mafia. Did you get any sense of concern that you were trying to prosecute one of the leading Mafia figures of the time, that your family was concerned of your welfare or their welfare?
You know, I didn't at that point. I can tell you a little bit. At that point, I was really not concerned. Frankly, I didn't think that the charge against the charge involved was of that momentous that even if he were convicted, which he eventually was, and the conviction upheld, I think the sentence was 15 days in the Essex County Jail. I didn't see that as anything to be really upset, for me to be frightened about it in any case. But, you know, I did think about that for a little while, but it reminds me of when I was in the U.S. Attorney's Office. I don't think I told this story. I did prosecute, I'm trying to remember the case, but it was a case involving organized crime figures, and also involving, because by the time I got to the U.S. Attorney's Office, there were many more cases involving organized crime, involving extortion, labor extortion cases, and that kind of thing. I was trying one particularly difficult one, and one which I was a little concerned for that, and being somewhat paranoid anyway at that point. We lived in East Orange, and we rented on a 2-family house, and we rented the first floor. But there was no place to park our car, so we were able to park our car. We paid for parking our car in the driveway 2 houses down. So I would go and park my car in there. And at night, I would take a piece of paper, and I'd take a piece of paper, and I would open up the hood, and I'd put the piece of paper between the hood, and then close it. The theory being, shows you how naive, theory being that, well, if I got out in the morning and the piece of paper was gone, I'd be somewhat concerned and maybe call up the Bureau, the FBI, to come and start my car or what. So I keep doing this. So one day, my wife is really hassling me about doing this and saying I'm really paranoid and all that. The kids are making fun of me doing this. So one morning I said, okay, I'll tell you how we're going to deal with this. You go start the car. I gave her the keys. I'm not starting the car. And that was fun. But that what I think was one of the times, bottom line was my car was always okay.
Of course, the famous scene in one of the Godfather movies where the car explodes when when his wife in Italy.
Right, I remember that. And I guess I don't know whether my paranoia was justified or not. Probably not. But when you're involved in some of those really complicated cases that have a lot of overtones that are would not necessarily be obvious when somebody, to the person watching a trial, but to somebody who's prosecuting it and who has access to all the FBI files and knows what's behind this and some of the tentacles that reach out of state, et cetera, and et cetera, you're more concerned about it, sure.
Let's move to another topic that is infamous in Newark history, the Newark riots. Talk about your memories and recollections of the riots.
As you know, and Don, I could go on for hours of this, so I will try to be conscious of the fact that we don't want to do it that long. As you know, the riots were in '67, I think in July of '67. I was not in Newark at that point. I was working in Washington. I think we went over some of this before. I was working, for the Attorney General in Washington as a special assistant. So I had no firsthand knowledge and was not here during the riots. I think in September of that year, Lyndon Johnson, president, appointed a commission called the Kerner Commission to look at the riots that had occurred in Newark, Detroit, LA, and a number of other cities. And about the same time, Governor Hughes in New Jersey appointed a similar commission chaired by Bob Lilly, who was then president of New Jersey Bell. And that commission was pretty much charged, somewhat similar to the Kerner Commission, to look into the causes of civil disorders, as he called it, in Newark and Patterson and also Englewood. He put on the commission an extraordinary group of people, very briefly. Bob Lilly was chair. Raymond Brown, who's probably the top criminal lawyer in New Jersey, he was then president of the NAACP, and an extraordinary human being, very active in civil rights and all that. Ray was the vice chairman. Ray, in fact, had been my opponent in the, I mentioned the Butenko case. I don't know if we talked about that. Well, we digressed to the U.S. Attorney's Office. That was a spy case. Want me to digress after the civil rights thing?
Yeah, why don't we finish that?
Okay, then we'll go in. Anyway, Ray, I got Ray known in the Butenko spy case. Anyway, and then there was Governor Driscoll, Governor Minor, former Governors Driscoll and Minor, Justice Wachenfeld, who had just retired from the Supreme Court, John Gibbons of the Third Circuit Court of Appeals, but then president of the New Jersey Bar, Oliver Lofton, who was a community activist and a lawyer, had also been in the U.S. Attorney's Office, Ben Lichter, who was a publisher of a newspaper, Bishop Dougherty, who was the chancellor of Seton Hall University, and Bishop, his name escapes me for a moment, who was then the head Episcopalian bishop in New Jersey. So it was an extraordinary commission. So I was in Washington working, as I said, in the Attorney General's office, and I got a phone call from Larry Bilder, who was Governor Hughes's chief assistant, I think chief of staff. And he said that the governor was coming down to Washington to meet with the president on some issue, and could he and the governor come over to my office at Justice and chat with me? Sure. So Hughes came over with Larry, and the upshot of it was they asked me if I'd like to be executive director of the commission. And I said to the governor, gee, let me think about that. I have no experience really in a lot of urban or race issues. Most of my experience has been in criminal law, to which Governor Hughes said, you can do that, you can do this. Hughes was that kind of guy. And I said, well, let me think a little bit about it, discuss it at home, and I'll get back to you quickly. So couple of days later, Larry calls and said, have you decided? And I said, I think so. I'm pretty interested. Well, he said, why don't you come up to Trenton and we'll talk about it. So I took the train up to Trenton and met Larry and went to see the governor. And the governor said, look, I'm ready to offer you the job. And I've talked to Bob Lilly and Ray Brown, and they're very pleased with you. In fact, the governor said the reason I even got to you was because of Ray Brown. Ray Brown had tried these 2 cases with you, and he likes you, respects you, thinks he'll do a really good job. And I like Ray, and anything Ray says, I'm happy to go along with. That's Dick Hughes. And Bob Lilly said, that's fine with me, too. So we talked for a little bit, and the governor said, I said, well, is there going to be money? Have you allocated? Everybody said, it's up to you. You can do what you want. I said, like what? He said, if you want to hire 5 guys from the Woodrow Wilson School to help you work this out, you can. And I said, I don't think that's what we're going to. I think there are a lot of real important issues here. And it's going to take a budget, and it's going to take an office, and it's going to take a staff. So he kind of looked at me and he said, well, what are you thinking of? So not having thought much about it, I said $150,000. I just threw the figure out. And he looked at Larry, and Larry said, well, we don't have that kind of money. And the governor said, we'll find it in the Department of Defense. Okay. And he said, okay, you'll get the $150,000. I'll charge the commission. Well, you and I will talk about what the charge should be. And the Department of Defense will handle all the logistics for you, so you don't have to do that. And it's your show from here on in with the commission. And so that's how I got chosen to be the executive director. And so then, it was then around October of '67, and I came up to Newark, and I left my family. It might have been earlier, maybe it was September. I can't remember exactly the month sequence, but I left the family in Washington because we had no place to live, and I came up here and I lived at my parents' house. My parents at then were living in Irvington, and I met with the commission, and Bob Lilly said, "Look, why don't you figure out a plan of action and then come back and we'll do it. We'll think about it." So I went back and talked to Paul Livasacker, who was then Commissioner of Community Affairs, talked to a couple of people I knew, and really sat down and tried to figure out how do I want to approach this. Okay, so I had a couple of things to do. One was figure out the approach. Secondly, then figure out how to get a staff to do that. And third, to find a place to do it. That was easy. The governor, they provided staff up in Newark. I mean, places up in Newark. But staff was going to be a real problem because to find people to work for 4 months or so would be difficult. But first was figuring out how to do it. I decided, and discussed this with the commission, that we would take a 2-pronged approach. One, we had to deal with the question of all the deaths that occurred. I think there were 23 deaths during the riots, many of which the allegation was had been shot by National Guard or state police or local police. And also we had to deal with the allegations that the state police had broken windows of black businessmen one evening on a rampage. And I felt, and the commission agreed, that if we didn't deal with that, the commission would have no credibility. The second issue was we had to deal with the political context and all the social and economic issues that created the context for the riot, and also would be important to know because what we were concerned with making recommendations. And without understanding the context and the background, we would have no way of making significant recommendations. So the thought was twofold. In order to do the first part, what happened, the deaths, et cetera, and the rioting, we would run the commission like a grand jury. I would hire a group of investigators, which Ray Brown was very helpful in. I got four fellows, 3 of which had been ex-cons who knew Newark real well. We had no subpoena power, so I had to rely on persuasiveness to get people. And these people would go out in the community, find people willing to testify. and then I would bring them in. The commission would meet every afternoon, every week, and I think we had something like 200 sessions. I can't remember the number, but it was an extraordinary number of sessions. We would meet from 3 o'clock to 8 o'clock every day. While I was doing that, and I would bring all the witnesses in a fairly logical way, and I would then hire a staff, and I would give each staff person a particular area, a political context, education, jobs, the court system, for example. And I'd say, you've got 2 months. Do whatever you can. What I want back from you is a report, an essay, of the context in which the riot occurred, plus recommendations as to how to deal with these things in the future. And so that when I would finish the grand jury part, and we had enough evidence in the record, I thought, then I would bring each one of these staff people and whoever they thought, you know, for example, if you needed the Commissioner of Education, or you needed to bring that person in to support your thesis, then I would present them, the individual with the report, and the commission would discuss that. And then at the end, I would try to bring all that together. So that was sort of the theory. And the theory worked. It worked for 2 reasons. One is that the commission was just really dedicated, and the commission members came almost to every meeting. And without that, you know, that would not have worked. And secondly, I think in a short period of time, by doing what we did and the word getting out in the community, we built up such credibility that I never had any problem getting witnesses. And whether we were talking to people who were from the community, or it was the Attorney General, the head of the state police, it never was a problem. I never had somebody who said, I'm not going to come. And I think it's because of the credibility. And third was that I think, you know, I really do think we developed a pretty good staff. I got people who knew people, and there were people who were housewives who would be willing to come for a couple hours a week and would do one part, and I knew somebody was leaving justice and somebody else was looking for another job, you know, and so little by little we were able to, and then Bob Lilly got somebody out of the Bell Telephone Company to help me with data collection and that kind of thing. So little by little I was able to put together a staff of people who were dedicated and who were really willing to do this. So I think those were the ingredients that then led us into doing what we did.
Of course, you're an alumnus of the Essex County Prosecutor's Office.
And the U.S. Attorney's Office and Department of Justice. Right. So that, God, I'm sorry, Don.
But under Brendan Byrne, and the prosecutions of many of the cases that arose from the riots was undertaken by the Essex County Prosecutor's Office under Brendan Byrne. Was your experience in the prosecutor's office viewed positively, or could it conceivably be criticized that there was some conflict because you had been so closely associated with many of the people?
I mean, I don't think so. You know, I had already left the prosecutor's office, and I had been in Washington for 2.5 years. I've been in the U.S. Attorney's Office for 2 years and in Washington for about 1.5 years. So there was some distance between that. And so I don't think so. I think what it did do is I think it gave me a lot of credibility in the community, because I think, at least my own opinion was, that I had a reputation for being a fair person, and I think I had a reputation for being a person of integrity. So I think the sense was that if I were doing this, it was going to be an honest job. So I think that helped. And the second point was that it was my experience. It was really my experience in both the U.S. Attorney's Office and in the Prosecutor's Office that enabled me to run that commission, at least that fact-finding part of it, because I knew how to ask questions. I knew how to get witnesses. I knew what was important to do that. I knew how to get, what ballistics reports we needed, what documentation we needed. I mean, I knew how to get all that stuff. So, and I knew how to run it. And I think if I had not had that experience, and I did this, we looked at this as a commission report that didn't do that kind of fact-finding that way, I don't think the commission report would have had anywhere near the acceptance which it did, which I think has been extraordinary. I mean, people will even come up to me today and say, that was just an extraordinary report. So I think that experience was really key in giving me the knowledge to be able to run this commission, and also help me with the commission members. I mean, you had two former governors, you got a Supreme Court justice, so you also have to. And I think I was 33 or 34, 35 at that point. You have to very quickly establish your credibility with them. If they're going to come and sit there for 3 or 4 hours, you want to make sure you're doing a good job and you're not wasting their time. So I think my experience and the reputation, which I thought was a good one, in the U.S. Attorney's Office and all that, I think was really helpful.
When you were approached about directing the commission, did you call Byrne from Washington and ask his opinion whether you should take the job?
Yeah, I did talk to Brendan. My recollection is I did talk to Brendan, and Brendan encouraged it. Brendan encouraged it to do it. Brendan was still a prosecutor, but he did. But I think I'm trying to remember the dates. Brendan was the prosecutor when the riots occurred, but very shortly thereafter he went on the Public Utilities Commission as commissioner. So I can't remember whether, when I talked to him, whether he was a commissioner on the BPU or he was the prosecutor. But I do, when I finally got up to New Jersey and started the investigation and all that, then Joe Lordi was, I think, the acting prosecutor at that time.
Do you recall whether Byrne was interviewed as part of the commission investigation?
Yes, yeah. Brendan was on our, if you look in the back of our report, I'm sorry I don't have a copy of it with me, but the report goes on, a couple of hundred pages of the report, but one of the things that we did that I think is very important is we have an index, obviously, where everybody testified, but then we have a long section in which every footnote that's in a report is justified, and all the documents that we used are there. And so you can pretty quickly take a look at it, and all that documentation was then finally sent down to the archives in Trenton. I mean, we had something like 1,200 witnesses were interviewed, and maybe 200 or 300 came before the commission. So it was a mammoth undertaking.
Mm-hmm. I think we have a couple loose ends on the career track that I just want to fill in. You had talked about getting bored writing appellate briefs and talking to Prosecutor Byrne about whether you could do things that would be a little bit more interesting, and he suggested dealing with the grand juries and the magistrates court. But at what time did you think, well, I'm still not having my juices provoked enough to stay, and wanted to think about the next job?
Well, I was vaguely thinking about it, but not to the point where I had made any overtures to look for anything or really think about it. And then, as many things in my life, the combination of serendipity, luck, circumstances came into play. And one very significant thing happened. David Satz, who was then the United States Attorney's Office, and I had finished trying. I ran into David at some occasion, I can't remember what. And David said that he was talking to Brendan, and he was looking for someone to be chief of the criminal division of the U.S. Attorney's Office. And Brendan had told him that he didn't want to lose me, but he thought that I would be a really good candidate for that. And Brendan, being a very decent and honest guy, also told him I was anxious to do trial work. And so Brendan said he told all that to Dave. And then Brendan told me all this, which was really very nice of Brendan. And then Dave called up and asked me to come down and see him, and then offered me the job as chief of the criminal division. Well, I could not turn that opportunity down for a couple of reasons. One, it was an opportunity to get to learn the federal system, And secondly, I could try the cases I wanted to try. As chief of the division, I could pick the cases I wanted to try. Third, it gave me a lot of administrative responsibility, and it was an important and significant job to do. So I said to Dave, yeah, I'd very much like to do that. And so I left, and then when I talked with Brendan, who had been helpful in mentioning my name to Dave, he perfectly understood and encouraged me and said, I think this would be a good move for you. So that's sort of how I made the transition from the prosecutor's office to the U.S. Attorney's office.
It's a bit divorced from your relationship with Brendan Byrne, but talk a little bit about the U.S. Attorney days.
Yeah, well, that was it was a very, very interesting experience. The U.S. Attorney's Office, as you know, is divided both into a criminal and a civil division. And while I was head of the criminal division, there was a colleague of mine, Vinnie Camisa, who then became a bankruptcy judge, was head of the civil division. And I instantly liked Vinnie, and the two of us, and he must have been 15 years older than me, but with a lot of experience. And Vinnie quickly picked up the fact that I had more chutzpah than I had experience. Mm-hmm. I'd only been in Brendan's office a year and a half, and I hadn't done very much. And so Vinnie decided that he would be really helpful to me very quietly. So whenever I had any questions of law or trial tactics or how to make a decision on a complicated case or so, I would quietly talk with Vinnie and so forth. And I always had a good relationship with Dave, who was a very decent guy. But Dave also had not had a vast experience in criminal law, so Dave was not the most helpful guy. He just didn't have the experience in the criminal law field. And as an assistant United States attorney or as chief of the criminal division, you also have to interact a lot with the Federal Bureau of Investigation, the Internal Revenue Service, and Immigration and Naturalization Service. And you work with them in making the decision whether to prosecute a case or not. So it's a little bit different than the state system. So you really have to get very familiar with the law. You got to understand the facts of the case, and you've got to develop close relationships with these federal agents so you're in a position to make those kind of decisions. And it was also my job to assign cases to the staff. And Dave did build up a really good staff. There were a lot of very good young attorneys. It was John Francis, who was Justice Francis' son, who was very competent. Matt Boylan, who went on to become a senior partner in a Lowenstein firm, a fellow by the name of Dick Levin, John Yauk. I mean, there were a number of Sid Zine on the civil side, a number of really young, really good. And plus there was one fellow by the name of Jerry Schweitzer, who had been there for maybe 20 years, 30 years. And so Jerry was a very, very helpful guy. So I liked the job. I got a lot of administrative experience. I liked working with the agents. And I also liked the kind of practice. The federal criminal practice at that time was very different than the state practice. I mean, it was a much more, I hate to use the word, much more sophisticated practice. There were tax cases, extortion cases, more complicated cases that involved many more, generally more defendants and generally much more difficult to prepare. So I like the challenge of dealing with those kinds of cases.
Did you get more trial experience?
Yes, I did. I finally did that, and I tried. Excuse me. I tried a variety of cases. I tried some. I tried one. I can tell you a little bit of some of those cases.
Sure.
I tried one labor extortion case, which involved. The reason it's interesting is, I'll tell you, is that it involved the old Kruger Brewery in Newark. But it was an unusual labor. It was a violation of one of the labor extortion laws. I forget the statute. But the reason it was so interesting to me was that it was not. The union was not, which some of those cases have been against union leaders, but this was not. This was against the owners of the brewery. And the union involved was the Teamsters Union, and Jimmy Hoffa's union. And we brought the case against the owner and some other people in the company. And so I'm trying this case, and I decide that, learning from the chief and from Ray Brown, that you really need to do something. This case needs a little pizzazz and fact here. So I decided that it would be really important to call Jimmy Hoffa as a government witness. And because Hoffa could testify that what the union did was perfectly proper and actually followed the law, and that would be helpful to my case. So I put a subpoena out to Jimmy Hoffa. Well, as things would happen, Bobby Kennedy was then Attorney General. And as you know, one of Bobby's main one of the things that really Bobby was interested in was Jimmy Hoffa. And that came from his time when he was head of that lawyer for that committee. So Bobby Kennedy had a practice which was really extraordinary. He went around to the U.S. Attorney's Office. So on that Friday, I'm in the middle of my case, and Jimmy Hoffa is going to come on a Monday, and my case is going on, and Friday was no trial day because of motions, as I said, and we're all gathered to meet Bobby Kennedy and 2 or 3 of his assistants. So we're sitting there, and everybody's introducing themselves to Kennedy, and he's talking about the office and all that. And so Kennedy comes to me, and he said, "You're the kid who's trying that case with Hoffa as a witness." And I said, "Yeah." And he said, "I understand you subpoenaed Hoffa for Monday." And I said, "Yes." He said, "You know that in 4 weeks, the Justice Department is trying Hoffa in Nashville on a jury tampering case. The first case we had tried against Jimmy Hoffa, where there was a hung jury, and as a result of that, we're now bringing a jury tampering case against him." I said, "Yes, I was familiar with that." He said, "I don't want anybody to interfere with Jimmy Hoffa." He said, "Why are you doing it?" I explained that. He said, "Well, if Hoffa testifies for you and you get subpoenaed by the defense and they ask you, did Jimmy Hoffa testify and how did he testify in your case, what would you do?" I said, "If I got a subpoena, I'm sure you'd want me to honor it. And I'd get down and I would testify truthfully. If he testified truthfully, I would testify as to what he testified. And if it was accurate, I would say that." He looked at me and he said, "I'll tell you what, kid." He said kid all the time.
He was about your age, wasn't he, at that time?
No, he was about, he must have been 8 or 9 years older than me. So he said, "I'll tell you what, you call him. I'm not going to tell you how to try the case, but I'll tell you right now, if you lose this case, and it hurts me too," said, "you've had it, you're fired. You're not going to be U.S. Attorney anymore. You're going to still do it." So being kind of pig-headed, I said, "Yeah, I'm going to do it." So I said, "Okay," and then that ended the thing. Jimmy Hoffa comes to my office on Monday morning. He walks into my office, and I introduce myself, and I say to him that I'd like to go over some of the questions. And I said, "You can have a lawyer." He said, "I don't need a lawyer. I'm going to tell the truth." And so I said, "Okay." So we go over the questions. And then the head marshal comes in and introduces himself to Hoffa, almost bows and scrapes, and said, "Mr. Hoffa, we're ready to escort you down to court." So I said, "I'm walking down too." So I walk out with Jimmy Hoffa and marshals. The whole hall to the courtroom is lined with Teamsters clapping for Jimmy. He's walking in. I'll never forget that. I walk into court, and the judge gets up and welcomes him, Jimmy, to court. Okay. So I figured, well, this is really something. The courtroom is packed, and for them all. Okay. So I put Hoffa on the stand and ask him the questions we had gone over, and he does testify fine and all that. So he leaves, and I shake hands with him, and he goes. Anyway, the sequel to the story is a couple of days later, the jury goes out, okay? So it's out for a really long time. So I get kind of nervous about that. Anyway, at about 11 o'clock at night, 10:30 or 11 o'clock at night, the jury comes back and with a conviction of these 2 guys in the Kruger Beering Company. So I go home, and I get home, and I guess it was after 12:30 at night. And as soon as I walk in there, the phone rings. And so I go to pick up the phone, And the secretary's on the phone, and she says to me that Attorney General wants to talk to you. That's Bobby Kennedy. So I pick up the phone, and Bobby, he says, look, he said, I called to congratulate you. I heard you won the case. I heard things went out really well. He said, you still got your job. And he said, what I really like to do, he said, I know, he said, I'd like you to bring your wife and your child. I had one child at that point. I'd like you to come down to Washington, and I'd like you to come up to the Attorney General's office. I'd like to meet them, and I'd like to say hello. So can you come down next week? So I said, sure. So I guess the next, I think it was Tuesday or so, we went down to Washington and went to see Bobby. And he had a big Tiger, and he takes my son, threw him up a couple of times, put him on the Tiger, gave us 3 or 4 of those PT boats. That was Jack Kennedy's thing. That always struck me as a really very, very interesting story. And I think Jaffe was convicted in Nashville later on the jury tampering stuff.
Was that your last contact with Bobby Kennedy?
Trying to think. Yeah, because by the time I went down to work in Justice, Bobby had been shot, and Nick Katzenbach was Attorney General, and Warren Christopher was a deputy. So when I went down there, he had already been shot.
Okay. Any other U.S. attorney?
Or
do you want to take a break? Or?
Well, it's almost 12, so maybe we should do what we can do, and then that'll. You wanted to quit at 12, right?
Roughly, but it's up to you. If you want to do another 10 minutes.
Yeah, why don't we do that?
Okay.
And, is that okay?
Yeah.
If we take a break to speak 10
okay.
minutes, yeah, we might as well.
So let's finish the U.S.
Attorney's Office. Why don't we do that? I think 2 other cases really come to my mind that to me kind of interesting. One involves a fellow by the name of Moriarty, who was known as the king of bookmakers in New Jersey, and particularly in Jersey City. And he ran the huge bookmaking operation. And he was arrested by the Internal Revenue Service, of all things, for the failure to buy a federal stamp if you're going to go into the bookmaking business. Federal crime. There's no federal crime of bookmaking. Anyway, he gets indicted, and Ray Brown gets to defend him, and so we're trying him, and I get the idea that I want to introduce some evidence to show he's in the bookmaking business. So case is I can't get any excitement in the case, I figured. And so I get the idea, and I talked to one of the IRS agents. When they arrested Moriarty, in his garage, they found something like, 100,000 policy slips, those slips in huge bags and stuff like that. So I put one of the IRS agents on the stand, and then ask him whether or not we go through the arrest and all that. And I then say to the judge, I'd like to introduce the evidence of that. So the judge thinks I'm going to introduce, 10 policy slips or not. And I said, Your Honor, yes. And turned to one of my IRS agents to the back and said, can you bring them in? Well, for the next 20 minutes, they wheel in these huge carts filled with policy slips, and Ray Brown is screaming away as they're going to prejudice the jury, to the point where the whole front of the federal courtroom was filled with policy slips. Anyway, I always got a kick out of doing that. And Ray looked at me afterwards, and when Ray came up to me one point, he said, that was pretty clever. I would have done that too. But he was screaming and yelling that I was prejudicing the jury. And I was saying, look, this is what they found when they arrested him, nonchalant, being very naive about it. Anyway, he was eventually convicted, but one of my colleagues, Sid Zion, who subsequently went on to write for the New York Post and the Times, the jury was, believe it or not, out about 2 days and didn't come out. And Sid always used to say, what's going on here? He's saying 2 million policy slips and it's taking a jury 2 days. I mean, he said it couldn't have been more obvious, the guy's in the numbers business. But, he had a nice reputation in Jersey City. So anyway, that was one case. The other case that I can talk a little bit about was that I found interesting, and I think the most challenging, probably up until the Riot Commission, the most challenging thing I had ever done. And that was trying the Butenko-Ivanov spy case. That was a fellow by the name of John Butenko, had worked for IT&T, big telecommunications corporation.
The old International Telephone and Telegraph.
And the other defendant was Igor Ivanov, who was a Russian national working for a Russian trading company in New York called Weintraub, but in reality was a KGB agent in this country under that guise. The charge, the FBI arrested both these guys, and Ivanov did not have any diplomatic immunity, so the Russians couldn't get him back on that. But arrested two of them on the charge that Butenko was passing secret information on the command and control system of the Strategic Air Command. In those days, in the middle of the Cold War, the Strategic Air Command was composed of B-1 bombers that constantly circled the globe and instantly being ready in case of an attack on the United States. And IT&T was working on the command and control system for that. It was a fairly complicated system. And so the allegation was that he had given these documents to the Soviet Union, and that Ivanov, with three other people, had been the people who he would exchange this. And they would generally meet surreptitiously in Englewood, in various places in Englewood. The other three people did have diplomatic immunity, so they were severed. They were never indicted, and they were sent back to the Soviet Union by the State Department. Anyway, the case came to our office, and I was handling the case and presented it to the grand jury and got the indictment. And so I put together a small team to help me in trying the case, and that was Oliver Lofton, who I mentioned, and a fellow by the name of John Cannell, and who were two of the younger assistants, and then that was my team. And Ray Brown was appointed by the court to represent Butenko. And a man by the name of Sam Launer, who subsequently became a judge, was retained by the Russian government to represent Ivanov. And Judge Oigeli was assigned the case in the federal district court. The case was a very difficult case for a number of reasons. There was no confession. There were no eyewitnesses. Basically, there were a series of observations by the FBI of surreptitious meetings. Okay, that was sort of one. And then there was a key piece of evidence that when the FBI arrested Butenko, on his person he had a small piece of paper, and on that paper was a map, and the map was of a railroad station in Englewood where they had met, and on the back of it were a series of 10 or 12 numbers. Okay, that was the evidence. We determined that those numbers comported with numbers of IT&T documents that were marked secret. So the inference was, if I could sustain it, was he was being given instructions by the Russians to meet at this particular place and asked by the Russians for those documents by those numbers. So that was inferential. That was basically the heart of the case. All right?
Did you think that the case was so thin as presented by the FBI to you?
No, I thought to me it was convincing, but I thought it was going to be difficult. I thought it was going to be difficult evidentiary because I had to get it in the evidence, and then I had to get in the documents to show that the documents were relevant, and then I had to show that the documents were secret. So there were going to be a number of steps. The other thing that complicated the case, which I did not find out until later, which I'll keep that anyway. So I worked with the FBI and their National Security Bureau to work all this out and get my witnesses, and I had got an Air Force colonel to testify the secrecy. But in order to prepare for the case, I really had to understand the system. So the head of the Justice Department's Internal Security Division said, you ought to go out to the Strategic Air Command in Omaha, Nebraska. So I went out to Omaha, Nebraska, where SAC had its headquarters, its worldwide headquarters. And I go out there with a couple of FBI agents, and they're going to demonstrate to me how this works, how the command system works, so I have an understanding of it. Well, that was a fascinating experience, because the command center is something like 50 feet underground, and you have to keep going through hallways and checkpoints with huge metal doors. So finally I get downstairs, down to the bottom, and I'm sitting up on a balcony, and in front of me are three huge, ever see the movie Dr. Strangelove? Mm-hmm. There are three huge screens. And on the screens one is a map of the world, and you can see various targets. Keep going? Yeah, you see various targets, places. The other is a map that shows where all the Strategic Air Command planes are, and then there was another one showing where submarines were, Polaris submarines armed with nuclear warheads are. So you see all that in front of you. And then on the first floor, really, are a group of Air Force people working all kinds of computers. And then they explained to me that in order to activate the nuclear arms on any one of the planes or the ships, it would take two people of a command level. And the reason is that there's a key here and a key there, and no one person could stretch to do it. The theory being, if there's an order by the president transmitted there to arm, you want to make sure you've got two guys there. You don't want one guy to have that responsibility. So I sit down, and the general there tells me to sit down upstairs. I sit down next to what is a red phone, where they would theoretically get the call from the White House. So the general said, just to give you an idea, why don't you pick up that phone and you issue a command to begin operations against the Soviet Union. So I do that, okay? Then all of a sudden, on these screens, I see these airplanes turn around and sort of head towards the Soviet Union. At the same time, you see tankers taking off to meet the planes at various places to refuel them in the air. And then teletypes go out to the various submarines. And so this goes on for about 10 or 15 minutes. And I turned to the general and said, we don't actually need to launch the attack for me to get to understand this. And he laughed and he said, no, he said, we do that every couple of days just to keep people sharp. Don't worry, I'll call them off. I'll call them off before they hit Russian airspace. And so, pulls them off and they all turn around. I figured out it was good news. So anyway, that was a very, very interesting experience. So then I come back and, I'm in the middle of trying my case. And I'll tell you one other quick thing about the case. So two things happened. One is I put on an Air Force colonel to establish the secrecy of the documents. Well, Ray Brown, who is such an extraordinary lawyer, effectively destroys this fellow on cross-examination. So I asked for a recess, which I get, and over the weekend, the Air Force has got to fly in a general now and bring him up to date, and I put him on the stand, and he was fine. But it was really a testament to Ray's skill. Anyway, so I get done with the government's case. And when I get done with the government's case, the Ray puts on a defense. Well, the first thing he puts on is he establishes through his investigator that there had been 2 illegal entries into the Butenka's house during this investigation, which I did not know anything about, which I had not been told. And so if that were really true, which it was, it could jeopardize my whole case. And Ray, being a very good lawyer, brought those motions, instead of bringing the motions to suppress prior to trial, waited for the government's case to go in so he could bring the motions at that point, and so double jeopardy would apply if the case got thrown out. So I kind of got annoyed at that, and so he puts this on, and I call for a recess. And I said to the judge that I did not know about this. I wanted some time to see whether I could establish that the evidence came independent of those break-ins. But also, I want to think about whether or not I want to establish that defense counsel knew about this and should have brought it back before, so the motion should be quashed and maybe he should be censured. That's a silly thing, okay? Well, Judge Masucci looks at me and gets really kind of upset about that, but he calls a recess. So I spent the whole weekend working with the FBI and trying to and establishing that enough evidence that I could establish that this did not, that they really found nothing, and so forth. But I also talked to Ray's investigator, and I was thinking about putting him on the stand. And I decided that I was not going to show that that the defense counsel knew, but I was going to show that he should have known. Okay? So I remember talking to Judge Masucci prior to trial, called me down and asked me what I planned to do, and he's kind of nervous about this. So on Monday morning, I'm really upset about doing this, but I feel I really need to do it. Ray and I had been friends, and up until then, Ray got really annoyed at me, and we broke off our friendship at one point when we were arguing the motions on Friday. In fact, Ray sort of almost threatened me in the courtroom, and I said I can have him arrested. I mean, the judge said, you guys calm down. Anyway, I get a phone call at 9:30 in the morning, right before I'm going to go to court, from Nick Katzenbach. And Nick is an attorney general, and he told me that he knows what I'm going to do, but he does not want me to pursue the motion to show that the defense lawyer should have known. He would prefer me to proceed on the grounds that I could establish independently that this did not affect the case. And he said the reasons are two. He said, since the Rosenberg case, spy cases in this country are under a cloud. And this is an important case. President's interested in this. I don't want this case to go off on that basis. I wanted you to do it on the merits. Well, I couldn't have been more pleased. And I said, sure, I'm happy to do that. So I went downstairs and told the judge that I wanted to withdraw that part of my motion on the fact he should have known, and that I wanted to proceed to show independent, which I then did. Anyway, the long and short of it, and this will end, it's that long tail. The case goes on, and it lasted, I think, about 3 weeks. I can't remember, 2.5 weeks. And both of the defendants were convicted. But the most interesting thing to me, and important thing to me, is before the summations, Ray Brown comes over to me. And prior to that, the rest of the week and a half, we never talked. He would come in that way, I would come in this way. The FBI agents were very happy. It bothered them that I was friendly with him to begin with. And Ray comes up to me, and I'll never forget this. He comes up to me, and he walks over to me, and he puts his arm around me and says, look, Sandy, it is really important to me that our friendship continue, and I want our friendship. And if we don't make up now, before summations, a number of things will be said in summation, and we'll never be friends. And how do you feel about that? So I shook hands with him. I'll never forget, Judge O'Kelly applauded from the bench. And so we've been very close friends since.
Let's end for today and
Good.
continue on another session.
Okay.